Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us a wonderful lawyer, Lisa Marquis, who I have known, 20-something years, probably 25 years, and I've seen her in action. She's excellent. Welcome, Lisa.
Hey, thanks, Melinda. Thanks for having me.
I'm so glad you came.
Of course.
So we're going to talk today about one of our favorite topics, collaborative law.
Yay, my favorite.
Let's assume, for purposes of our conversation, that our audience does not know what we are talking about.
Okay.
So how would you explain what is collaborative?
Well, I'd start by explaining the difference between what I'm going to call the little c collaborative and the big C collaborative. Collaborative is a word. It's kind of the word du jour, right? A lot of people want to be collaborative in all aspects of their life. And so sometimes I'll have somebody come in and they will use the word collaborative, but what they really mean is what we used to call, when we met all those years ago, amicable or uncontested.
Friendly. Let's be friendly.
We're going to get along. We're going to do it all by agreement. But the big C in collaborative is actually within our family code. It is a method of alternative dispute resolution that is codified to have very specific requirements of what constitutes a collaborative divorce process. And when people sign up for that process, the best part about it to me is they get out of the court. They don't get out of the court system because their case is still pending, but we get removed from the court's docket, and those clients get to maintain absolute control over how their divorce process moves forward.
So if they're not in the collaborative process, what are they in?
Well, they can be in a lot of different processes, but typically we talk about litigation, and that is the scenario where people can certainly come to an agreement in litigation and not ever have the court make decisions for them, right? I mean, that is, what is it? And I think the numbers have fallen in recent years, but 85-90% of cases settle without ever going to court. But when you're in the litigation model, you are subject to the deadlines being imposed by the courts, which, by the way, the courts are getting a lot of pressure from the legislature to move things along. And so it is another benefit, I think, of being in the collaborative process to not be subject to those artificial time constraints. So litigation is one of those processes. A lot of people do still do what we would call in the old days traditional uncontested divorce, where either through informal settlement conferences or the spouses just working together will come to an agreement.
I call that the kitchen table deal.
Kitchen table method. That's right. That's right.
But the default method is litigation. If they don't opt into collaborative, they are in litigation, whether they do it at the kitchen table or they actually have fight to the death litigation.
Exactly right. Yes. They have to opt into the collaborative process.
So why were you attracted to collaborative, and how long have you been doing it?
So I did my first collaborative training in 2000, went down to Houston for the training, and I realized at the time that it was really the way I handled my cases anyway. How could we help these families transition through a really difficult time in their life where they were the ones making the decisions? And for me, not being subjected to the court's deadlines and so forth, and being able to accommodate the special needs of clients that were going through this. I mean, I've had cases where, they had an adult child suffering with addiction issues. They needed to put things on hold so they could take care of their child. And no disrespect to our courts, but that system is not really set up to accommodate those kinds of needs.
And you still litigate also, true?
Yes, I do. Unfortunately, yes.
Well, I'm like you. I do both, litigate and collaborate. But I also believe that collaboration is the better path. And the only reason I litigate is some people will not select collaborative, or my client would select it, but their spouse is too crazy to select it.
Correct.
Or too crazy to do it. And so then we have to litigate. But I agree with you. Collaborative is the way to go. I've noticed that both for professionals and for clients, people are attracted to collaborative for different reasons.
Correct.
You talked about control, like controlling their own destiny instead of a judge controlling it. What are some other reasons that you think people attract to it?
I think privacy is very high on the list. Whether it's because of the size of their estate, or it's because they've got some personal issues that they want to make sure do not become public for work reasons or whatever. But privacy is way up there on the list. I think for some people, a lot of times we get clients that come in where one spouse has always handled the kiddo issues. They're taking care of the kids, and the other spouse has handled the finances and so forth. And it allows us a chance to get those clients on equal playing fields. So the spouse who handled all the kiddo issues has an opportunity to be educated about the finances before they're asked to make a decision about what they want in that part of the divorce. And by the same token, especially bringing in the mental health professionals that we bring onto the team, it really allows parents to make educated decisions on what a schedule should look like for their kids and how they're going to make decisions for their kids. So I think the educational piece that the process offers, a lot of that being offered by our neutrals that come in because they have their specialty areas. I think that's another area. I think that there's the cost issue always comes up, right? How much is this going to cost?
Yes.
And some of the naysayers of collaborative say, it's more expensive. And I tell clients, it is certainly more expensive than that kitchen table method that we talked about, right?
Right.
But if you're comparing it to the cost of a full-blown trial and full-blown discovery and all of that, not only is it less expensive financially, it's also less expensive emotionally. I don't think most people go through their life without ever being in a courtroom, right? But I have clients who are terrified of the thought of being on the stand, right? And so
because it is horrible.
It is horrible.
For the record, it's horrible.
It is not where you want to be at all. And so I think just more of that peace of mind is another big advantage to it.
Okay, so you mentioned a lot of things I'm going to skip back to. You talked about the neutrals and that it's common and collaborative to hire neutrals. Tell us what the common neutrals are to involve.
The two most common neutrals are a mental health professional who, for those of you who don't like therapy, it's not therapeutic, right? They are there to serve as a communications coach. They also do a fabulous job with their children involved in terms of coming up with your parenting time schedule and your parenting plan. And they serve that role on the communications coach even within the meetings, right? Because sometimes lawyers, we have to get a little coaching too.
They're the facilitator. They're facilitating us sometimes.
Yeah, that's right. That's right. And then the other most common neutral is the financial neutral. And what they do is they come in and they gather all the financial data and they put together our spreadsheet so we can determine what the assets and liabilities are that we have to address in the divorce. They also will help clients in terms of preparing a post-divorce budget so they know what they need to in order to, move forward after the divorce. Sometimes when I have the higher wage earning spouse, I'm wanting to make sure they're not overcommitting to what they can feasibly do because we don't want them to get in trouble down the road. But they do not, again, these are neutrals. And I think that's the critical part. They're not going to take sides. Their job is for the mental health professional, let's make sure everybody feels safe in that room and as they're communicating. For the financial neutral, let's make sure everybody has all the information they need in order to move into the decision-making process. Now, we also will bring in a child specialist on occasion, which is a newer member to the team. And they have a very limited role of really educating the team and the parents on where the children are coming from as they face their new normal going forward. So those are the big ones.
I love the neutrals. It's not in the statute. It's not required to do collaborative with neutrals, but I act like it is. I tell potential clients or clients, collaborative does include neutrals. And I think most of us that do it very actively almost always have the neutrals. And that's something you might say, ooh, that sounds expensive. How are we paying all these people? But we're really fee shifting some. Would you agree?
Have we got a deal for you? No. No, seriously, if you think about the litigation model, and the financial neutral is the easiest one to explain this for. So in a litigation model, you and I are on opposite sides of the case. Your client's going to give you a data dump with all these statements and an inventory worksheet, and you're going to put together your inventory. My client's going to do the same to me. I'm going to bill for that at my hourly rate, and you're going to bill for it at your hourly rate. We're going to exchange those documents, compare notes, and fight about a few.
And we're both going to create our own spreadsheet.
And we're going to create our own spreadsheet. And then, we get the stylistic arguments that go on. But in the collaborative case, there's one person who's pulling all of that together. And let's be honest, we can do math, but we're not financial geniuses. I mean,
they're more qualified. Is that what you're saying?
That's their sandbox, right? I mean, that's what they do. And they will pick up on things that I would not necessarily pick up on. And for whatever reason, when that person asks one of the spouses for more documents, it's much more well received than when opposing counsel asks for those documents.
It's not met with as much suspicion.
That's correct.
Yes, so I agree. I think it's fee shifting. The lawyers in the world don't love to hear this. We're taking money from the lawyers and giving it to the neutrals. But I think that's what's really happening. And therefore, it's not terribly more expensive to involve those people. To your point, expense is really determined by how easy or slow these people are to reach agreement. If somebody comes in and they say, hey, we've already agreed on everything, and that's true, right? Because sometimes people say that and
it's not.
No.
The truth. They want to get divorced. They don't agree on anything else, but they agree they want to get divorced.
But let's say it is true. It's a fairly simple situation, and they are both sophisticated enough, and one isn't just shining on the other one by nodding, that they really do have accord. They don't need a big process like collaborative. This is a process for people who do not agree.
It's a process for people who want to agree.
Yes.
They want to genuinely have a desire to do what's best for their children and their family. But they need a little help. And whether that's, because they don't have the knowledge or the information that they need, or they want to be ultra creative. Mm-hmm. I will tell you, the creativity can make it a little bit more difficult for the lawyers because we get to draft those agreements. But I'm always happy to do that because I find that when people have an investment in coming up with that solution, mm-hmm. it sticks better than just slapping on a standard possession order, for example.
I like how you phrase that. They want to agree, because it might not be that they even explored agreement yet because they have a complex estate and they don't even know what possible agreements might exist. So with wealthy people who have family limited partnerships and trusts and entities that they own, it would not be simple for them to sit at the kitchen table and just say, oh, well, you get this and I get this and you get this. For one, there's rules for each of those assets. Are they divisible or not? Could they be put in one person's name? Is that going to cause a tax effect? Are we ruining their estate planning by undoing it? So they need assistance in order to get to a point where they could agree.
Exactly. And you bring up a good point with the small businesses, right? I mean, the number of small businesses that go under because of divorce it's a scary, scary number, right? And so in the world of neutrals, we talked about the main ones, but in business valuation is a complex area, right? And if we're in the litigation mode, I'm going to hire my business expert. You're going to hire your business expert for lots and lots of money. They're both going to come in and testify. And the judge has to determine credibility and which one to go with or split the difference, right? In the collaborative process, talk about cost savings, where we as the collaborative attorneys can select someone who is collaboratively trained, but who does business valuation and understands that their job isn't for one party or the other. It's to help this family come up with what the right valuation is. That's a huge cost savings for people who have business entities involved in the divorce.
Yes, and we're trying not to overly disrupt the business while we're getting divorced. In litigation, sometimes there's a little disruption occurring.
Sometimes there's a lot of disruption occurring.
So that's a huge benefit. I like what you said before also about creativity. That is what attracted me to this process. Besides recognizing that certainly there has to be a better way, because you're litigating and you're thinking, we're hurting this family. Like,
Right.
not only are we trying to divorce them, which may or may not be hurting them, right? That could be a different day of conversation. But assuming that they do need a divorce, we were making their situation worse because the only tools available to us were things that kind of make it worse by going the litigation path. So I immediately was like, oh, this could, be a better way. Like, why wouldn't we want to go about this in a better way? But besides that, I love and am attracted to the creativity, meaning for our audience, the court is limited by the law, right? So there's only certain things a judge is allowed to do. And whether we're in collaborative or mediation, which I mediate as the mediator, as you know,
Right.
we can be more creative than the judge. And I love that because there's a lot of great solutions that just are not available to the judge, but that would be great for this family. And I'm a idea person. I like to think of all those ideas.
Right.
Now, sometimes people are like, that's too many ideas. Stop the ideas, Melinda. You're making it too complicated, because it does become complicated, like you said, from a drafting perspective. Like, okay, this is a great idea. How do we make it so? But I think for clients, it's so nice that we could come up with something that meets their specific circumstance.
Right.
And I think that's attractive. It can be attractive to clients. But there's also people who they don't want creativity. They're happy with what a court would do. They just want to do it in a more amicable way.
Right.
That's okay, right? We don't have to be creative.
Well, I think those of us who've been collaboratively trained, I'll just speak for myself. I mean, even if I have a case that's in litigation, the way I am approaching that case, the tools I've learned through all the collaborative training come into play, especially in mediation, because we've learned it's okay to think outside the box and be creative, as long as we can document it and draft it correctly. And so I think you're absolutely right. And when clients are invested in that creativity and have a voice in it, there's going to be more buy-in to what that end result is.
Yes. Okay, let's talk about our favorite topic, discovery.
That is not my favorite topic.
So in the collaborative statute, it says we do not do formal discovery. So please explain to our audience, what is formal discovery and why aren't we doing it in collaborative, and what do we do instead?
Oh, I have to be careful how I answer this question. So in the collaborative process, when you sign the collaborative participation agreement and the clients sign it as well, it says that you are committing to full and fair and accurate disclosure. And it is presumed that a request from the other side for information is reasonable. And so what we don't do is, I don't say, I need your client's two years of your client's cell phone records. Don't know why, but I mean, those are the requests we get. Or we get discovery requests in litigation. Every document related to this from the date of marriage. Well, when you have people who've been married 25 years, that's a lot of documents.
Yes.
And not really reasonable. And you can spend a whole lot of money gathering that stuff
In litigation.
in
a discovery fight.
and even, trying to look through it, right? And so, and while we don't do formal discovery in collaborative, this is where the trust between the team members comes up, that I'm trusting that you're asking your client to provide the information that my client feels that he or she needs to make decisions. But also, on the flip side, for people who think that discovery and litigation gets them all the information that they're asking for, I've got news for them. That there's no magic wand.
It's a keep away game
that makes people turn that stuff over. And you can spend a whole lot of money trying to get documents that may or may not even show what you think they're going to show. And some people, especially in litigation, will do it just because they can ask for it. Some lawyers, they have their 50 boilerplate requests for production that they're going to send out. Not even necessarily related to this particular case. They don't tailor it.
They do not tailor it to the case. And then you have to object and say, what are you talking about? These people don't even have a business.
Right.
Why are you asking for the business records?
Right. And so I think that I look at it more as a more tailored method of discovery. You can still ask the questions that you need to ask. And that financial neutral plays a huge role in this process because as they're analyzing the documents, tax returns have a wealth of information in them.
Indeed, they do.
So when the financial neutral is looking at the tax return and they see, oh, there's dividends from Charles Schwab. I didn't get any Charles Schwab accounts statements. For whatever reason, when they ask the clients for that, it's like, oh my gosh, let me dig those up. I'm sorry. When we ask the other side, what are they accusing me of? Right?
Right.
It's a totally different mindset.
Yes, the power of the neutral voice
Exactly.
in asking for information and also in making suggestions.
Yes.
If a suggestion comes from me or my client, it is often met with, why is that good for them and bad for me? But if a suggestion comes from a neutral, they can just accept this suggestion as a possible idea.
They can accept it that the neutral needs it for them to be able to do their job.
Yes.
And that's a whole different reasoning process.
Yes. I love the neutral voice. I think it's very, very powerful.
It is.
Okay. So in the full disclosure of information, back to that, and collaborative, it says, like you said, we sign a contract that says we're going to provide anything anybody wants. That could be a piece of paper, but it could also be information like, are you having an affair?
Right.
And they're supposed to answer, right?
They're supposed to answer. I'll share a quick story with you that it wasn't the existence of the affair. That was known. But the party who had been unfaithful had spent some money, some community money, and it was on a credit card that was only in his name. And it was not being considered in the property division. He was going to take that no matter what, right? So it wasn't going to be factored in. And at one point, the wife's attorney the wife asked for the statements. Well, the mental health professional who had met with the wife and knew how fragile she was, we have a team call, and she says to the wife's attorney, I think it may do her more harm than good.
Oh, how
To
interesting.
see what's in those statements. And if it's not hurting her financially, because it's, again, he's paying for it 100% out of his post-divorce money, it was enlightening to me. Because I can guarantee you in a litigation case, it would have been a fight to the death to get and my client would have had no choice but to turn them over, right?
Eventually,
Right. But I think the neutral voice coming in and saying, I've met with her.
Mm-hmm.
I know how devastating this is for her emotionally. And what does she really benefit from seeing that? And so the lawyer went back and had the conversation with her client. It was ultimately her client's decision, right?
Mm-hmm.
And her client acknowledged that, it would be more hurtful for her to see them than not. So that's a way where the more narrow, specific discovery, I mean, it was there, we knew it, but we were able to approach it from, I guess that return on investment, if you will, but looking at would it do more harm than good?
Yes.
To share that information.
Yes.
And I think that way with the affairs as well, definitely don't want people throwing it in the face of their other spouse in the middle of a joint session. That can have very negative.
Let's pick our timing if we're going to explore that.
But I think collaborative gives us a chance to ask the why.
Mm-hmm.
The why behind the request, as opposed to, here's my boilerplate 50 request for production.
Right.
Why do you need this?
Yeah.
And evaluate it that way.
I agree. Okay, new question. Does collaborative work for people who have substance abuse problems or mental health problems?
Interesting question. The short answer is yes, with a caveat. One, you have to address them. They have to be addressed up front. And one of my most successful collaborative cases, husband had a severe alcohol problem and actually went into inpatient treatment. But they had 2 young girls, and maintaining that healthy relationship with dad was very important for my client. And because we knew about it,
Mm-hmm.
and with the help of a very strong mental health neutral, we were able to help that family negotiate that process, which included dad having a certain amount of treatment, but dad's therapist also dad signing a release for dad's therapist to talk to our mental health neutral. So our mental health neutral could monitor the steps that were going on, and then help advise the parents on what was best for the kids based on where dad was at that time. And I have one right now where we have a client with limited capacity, and we've brought in an ad litem as a guardian ad litem for that spouse who also has an attorney. But again, we know about the limitations. I would say, and some of my colleagues may disagree with this, but I don't think so. Domestic violence is kind of a non-starter because they have to be in the same room together, and there's a perceived intimidation factor, right? So I'm not talking about the clients that say he's mean to me, right? I mean, I'm not talking about that, but true domestic violence where there's protective orders and those kind of things, that's probably one scenario that it will not ever work in. But I think any of the other issues, as long as we know about them and we're dealing with them, sure. Because the other side of that is those families are not going to be better off in litigation.
Yeah, they have to get divorced somehow.
They have to get divorced somehow, and litigation is not the place for those families to be.
I agree. I think that I lean way towards almost any case could be collaborative. And even in the community, some people say, well, not this kind of case, or maybe they just don't want to do it. That's okay. We don't have to do any case we don't want to do. But I think collaborative process in most instances can deal with people's problems or challenges or whatever's presenting better than the court system can. And if we have a team, gosh, how wonderful to have the resources of the team to help say, gosh, what should we do to help these people? And in collaborative, even though I'm only representing one side and you're representing one side, we're both in it to help them as a family. And you really feel that in a collaborative setting more than we do in a litigation setting.
Right.
So I would even say, I mean, the family code does allow for domestic violence to be handled in collaborative. You just have to take steps to be protective.
Right.
And with Zoom, you could do everything without ever being in person. You could typically we meet in collaborative all together, but it's not required by the statute. So you could have caucus style like we would for mediation, but still have a collaborative setting, which would still meet some goals such as privacy or control from the court.
I just think you would have to very clearly and carefully screen those cases.
Yes.
Because if it's if it's a situation where there was an event that occurred and it's being dealt with through the criminal courts or whatever, that's one thing. If it is an ongoing pattern of abuse and intimidation and control, so you have to be really careful about that.
Yeah.
And I think we have to be cognizant of not putting the square peg in the round hole, right? I mean, there are some cases where no matter how much your client wants to do it collaborative, if you know the other person is never going to show up to a meeting and they're going to drag it out, because that is a downside to collaborative, is not being able to have a way to force people to come to the table, right? I mean, if you're in litigation,
set it for trial,
and you have a hearing set and the other side doesn't show up, they're going to reap what they sow, right?
Yeah.
In collaborative, so you have to be aware of games that people play, and that's where the mental health professional can come in terms of a pre-meeting, like before the participation agreement is signed, they can meet with the clients, and sometimes their assessment can be helpful in determining whether it is suitable for the collaborative process.
For me, the case that cannot go into collaborative is if somebody is truly crazy. Now, plenty of people are divorce crazy. That's different because we all feel a little crazy when we're going through divorce. But when somebody is literally crazy, and the DM5 or whatever number we're on now, it doesn't say the word crazy, right? But they have a mental disorder to the extent that they cannot enter into a collaborative type discussion and enter into an agreement. That is when you have to have a judge decide, because they're never going to be able to do it. Now, it's not always easy to judge when someone comes in. Are they divorce crazy, which just means not at their best, or are they literally crazy?
Right.
So that's hard sometimes to know. But to me, that's the group that you have to have the help of the court system, because nobody They're just not capable of doing
Right.
it. But other types of mental health, people who have bipolar, but they're actively being treated, they can do it.
Sure.
There's
Absolutely.
a lot of people come in and say everybody's a narcissist. Well, they can still do it in most cases, If somebody's actively tending to their mental health, or we can get them to actively tend to it during the case, then I think they can do it.
Yeah, I agree. And I think that all of those are, there's varying degrees of it, right?
Yes.
And so again, I think, and that's where who is on your team is so critical to the success of that particular process.
Yes. Okay. Well, we're out of time, but I want to have the audience know how to find you. So where is your practice, Lisa?
So I am in the Plano office of Quilling Sealander. We're at Tennyson and Atollway in Plano. You can reach me at 214-880-1835 or L Marquis, Marquis, at qslwm.com.
Thank you so much for being here.
Thanks, Melinda.
Well, I cannot recommend Lisa Marquis enough. If you have a need for collaborative in the Collin County, Dallas area, call her. She will help you. And I'd love to be on the other side of that case.
Amen.
We like having cases together. Thank you so much for listening. Please tune in again to the Melinda Eitzen Show. And if you have anything you'd like to hear about, let us know. And you can email me at melinda@d-elaw.com. Thanks for watching.